record. All right, welcome everybody. We got a special guest on with us today. We're going to go into we got Todd Duel, and we're going to go into the movie premiere, which is called BirthRight Movie. It's at BirthRight Movie, and you could check it out on the at BirthRight Movie. That's their X account. They also got a website, and Todd is one of the experts in the movie, including David Straight, including Ron Gibson, and many others. It's coming out on Thursday on Thanksgiving Day, so you could check it out on the premiere. And I want to have Lisa Writing give an introduction to Todd. So, Lisa, welcome.
Thank you. Happy to be here today, and want to let you know I actually got to see the premiere and several of the groups that were down in Hollywood prior to it going out in the Independent Film Festival. And it's an amazing documentary. It's actually in two parts, and it's about a 4 hour documentary. First part is very focused on. I'll let Todd talk a little bit more about it. But basically helping you understand and comprehend the web in which it works. And I have personal background with Todd, and he has helped me not only become a secure party creditor and a holder of due course, but he has also spent a great amount of time working with my family and my friends and helping us really understand what our rights are. Todd is not only spoke at the Independent convention. He is a very much so very well respected in this space. He's a trust protector. And I don't know if you want to stalk his LinkedIn, but he's actually an educator. He's proficient at trying to get the cases out there and knowledge out there, but he's also a dear friend and a love for the Constitution and what trust means. So, Todd, uh, thank you so much for coming on and talking to our group, and also the movie is phenomenal. I encourage everybody to see both parts of it.
Thank you,
Yeah, the
Lisa.
movie was is absolutely fantastic. I did get to go to the LA premiere and had a really good time with everybody. And it really hits home on a lot of things. And Lisa, of course, has more another version of the movie coming out next year and possibly some shorter clips of different topics and things like that for people to expand on specific topics people are asking questions about. And at the INC conference that I was asked to speak at it by Robert Kennedy, it was pretty awesome to sit at the panel group up there because they asked me to talk about two different topics. Obviously, one was about sovereignty and one was about trust. Because the group there for the presidential nomination wanted to explain to people how to use a trust to protect yourself and protect your family from overreach from the government, because that's exactly what they're doing. And I see it all the time with my trust clients that come to me that have living trusts that are getting smashed in the courts, and the courts and the government are taking over their trusts and liquidating everything for pennies on the dollar to pay creditors and things like that. And I see this travesty all the time. And I have to point out just the very basic concept of the IRS has this thing called a complex irrevocable trust. There's literally check boxes on the IRS documentation for what type of trust you're looking for. And that's the one they don't have jurisdiction over because it's private. It doesn't fall under the court and control test because you split legal and equitable title. So that's the proper way to operate. It's the proper way our families operated for a very long time. But I thought at the conference, the most important thing that we got across were literally the other bar attorneys that were on the panel discussion. As soon as I dropped some of these cases and explained what was happening, they understood what I was telling the crowd there that was listening, that even under the cases like Perry versus United States, Chisholm versus Georgia, and Guaranteed Trust versus Henwood, the United States Constitution is a trust. We are the grantors, we are the beneficiaries, and our elected and appointed politicians are the trustees. This is well known, well understood. Nobody argues this, right? Until we try to figure out how do you control your politicians. Well, if that thing is a trust, go ahead and revoke and revest it under the merger rule for trust and collapse it. This has actually been done in several countries in the last year. The main one that started this off was New Zealand, where the Maori basically went in to the parliament and in their native tongue revoked and revested and shut parliament down. So it can be done, and it can be done under the striking clause, which is 5 USC 55 or 3331 through 3333 and 7311. because they're striking against Article 4, Section 4, the Republican form of our government, which was guaranteed to us and created a democracy so we can shut the trust down, right? But it takes people to have enough nerve to walk into a House and a Senate hearing, right, in the middle of the Senate, and as the people revoke and revest the Constitution.
So Todd,
So that's when I name those cases and I name the statute to do it. That's when the attorney's like jaws hit the floor.
if
And
there's any way you could come a little bit closer to the mic, it would be better if possible,
yeah,
or maybe turn the mic up. Yeah, that'd be awesome. So, and then
so hopefully that makes sense to everybody.
yeah,
The Constitution is a trust contract. It has to be, because somebody has to be the beneficiary of it. Somebody has to administer it. That means there is a trustee, right? They gave us all the protections of the trust, and people are not understanding how to revoke and revest a trust.
right. So can I take me back to kind of the beginning? And I want to know your story as well. And we want to start there in the beginning, but also the movie. So before we go, I want to kind of talk about your story. But before we do that, can you tell me about the movie? Because I know it was you and David Straight and other people in the movie that are really well known that I've already seen previews of. So how did this kind of come about? How did you get involved in this film?
I was invited to speak at the conference as one of the main speakers and have several different sessions. And then while I was there, Lisa was basically like doing like a preview of the movie that she was going to release. And, we met and we talked through one of our other colleagues that we're associated with. And she was just like, oh my gosh, we're missing a lot of content. And do you have this? And I said, yes, I absolutely have certified documents of all of these things that I'm talking about. They're actually publicly available if you know where to find them. You can get certified copies of this stuff. And so we were able to bridge the gap on quite a few things that Lisa had been looking for a very long time that people like David Straight didn't have. He was very knowledgeable in that space about what they were doing, but he couldn't necessarily back it with real documents. So I've been able to, for like the next movie, I've actually been able to feed Lisa all the real documents, things like the Trust Indenture Act, right? That's like the attorney's kryptonite, because that's what they're managing our trust under. They created that trust in 1939 and renewed it in 2010 so that they had the right to manage our estate and trust through our minor account. They're the custodians, they're the trustees, right?
Yeah.
It's all right there and it's all approved by Congress. They know what they're doing.
Now, a lot of the stuff's going to be over a lot of people's head who are going to see this in the beginning because you're like the advanced enforcement guy, and so take me back. But before we get to that too far, take me back down to the beginning. Like when you and I first met, you told me the story about how your dad was in the court, and then your neighbors were at the Federal Reserve. Can you tell me back to the beginning about where you grew up and how that all happened?
I grew up in the Bay Area in Cupertino, home of Apple Computer. And my dad was a judge and law school professor there. And he actually was doing that in the 70s and 80s when they switched over to this commercial bonding underwriting system for the courts because they were broke. And so they decided under Ronald Reagan's tenure that they were going to use the GSA bond. So they created the 1418 form, which is basically, it says it's a bond for anything other than a construction contract. So they started using those GSA forms to bond the court cases to extract money from the estate of the defendants so they could fund themselves. And my dad kind of flipped out and he's just like, and you want me to do this with no bonding and underwriting and no securities license? He's like, oh, hell no. And so I had to, as I was working in my dad's, law office and clerking and things like that, I had to write his checks to his surety company because he bonded himself. He's like, I'm not going without a bond doing this kind of stuff. If I get sued, I'm going to jail. He's like, no way, am I doing that? So, he had a really hard time with that. And it just so happened that my dad was also the general counsel for my aunt and uncle's bank, the Arizona State Bank and Mojave State Bank. So, we would spend a lot of time during the holidays and summers and stuff like that. And I would go into the bank with my uncle, who was the president. My aunt was the CFO. And so I got to see the underpinnings on how like loans are not loans, they're an extension of your credit. Because our next door neighbor was the TILA officer, the Truth in Lending Officer for the Federal Reserve. So Yeah, there's no loan. It's an extension of credit. This is actually extremely well known. It's documented in Title 12. It's documented all over the Federal Reserve's website. But you go into a court case and you say there was no loan, it was an extension of my credit, and they gaslight you. Well, fine. Then that thing is a trust. Revoke and revest that thing, and let's liquidate it. Let's go after the indenture trustee for embezzlement, and we'll take you in the U.S. tax court. Right?
So it sounds so simple. So now let's go. So you're
Yeah.
growing up, I know it sounds simple. You went right for the remedy as well as you always do. So
Sure.
so your dad was a judge and you're going to you're growing up here in Cupertino in the Bay Area. And then, he realized there's a problem because of the insurance bonds. He's like, oh, we're going to get sued. I might get
Yeah.
sued. And Ronald Reagan apparently appointed him to
Yeah.
this task force or, what
No,
was that
not
all about?
he didn't appoint my dad in the task force.
Okay.
Ronald Reagan was the one that approved basically the use of the GSA bonds to fund the judicial system. They were broke.
Ah, okay.
Just like our government's broke now. So what do you think they're doing? They're filing 1099-As with no commercial paper. They're broke.
Yeah. So they started making
It's
money on the
absolute insanity
bonds.
what they think they can get away with and nobody's paying attention. But under the IRS statutes, if they don't provide you with your 1099-A, that's tax preparation fraud because they're filling it out as they're the lender, you're the borrower. That's fraud. You're the lender, they're the borrower. They owe the taxes. This is tax evasion by our government.
So what led you down the road further after that? You wanted to why didn't you just become an attorney or, what was the
Well, attorneys can only represent legally incompetent minors, right? They cannot do the accounting in the courtroom. You will be immediately sanctioned and disbarred. Can't be done. The attorneys can't do this. They're not allowed to. You have to have a really, and I apologize to everybody, but you have to have a really big set of balls as an attorney. You have to have a lot of clout to go into the chambers with the judge and do equitable subrogation and handle the accounting. They're going to be super pissed at you, right? Because you're not supposed to know to do that, and you're not supposed to do that to the court because it puts the court in a massive position of liability. If the client ever finds out, they have a tort against the clerk of the court, the judge, and all the attorneys. There is so much case law against them where they've been charged criminally for this kind of stuff, and the IRS has it. All they know is if this gets to the IRS, it's game over for them. It's a matter of time before they go to prison.
So, I mean, you're really advanced and clearly on another level. So I'm just wondering take me back more to the early days where how you're even getting there. I know it was your dad was saying, hey, we got a problem. I want you to learn this stuff. I mean, how did
Yeah.
it even, is that what happened?
Yeah, because even as the youngest child, my dad knew that I was inclined to this type of truth and this type of logic that I wouldn't be corrupted onto the black hat side where my sister, my bar attorney sister's at. So she's on the corrupt side. And so I'm actually going to drop this into the comments for everybody so you can see what the IRS uses against them, just as a basic primer. So yeah, he knew I couldn't be corrupted and that I would actually handle the trust. And even my older sisters, they all looked at me when it was time for somebody to take over the trust, and they said, "You're the best person for the job because you'll follow it to the letter." Like, even though I was the youngest.
Do you want me to open this document, Todd? I can
Sure.
share this. Let me share this on the screen. Hold on a second here. All right.
This is straight out of the IRS's own manual for how they prosecute the judges and attorneys.
Now, Todd, I think that as Gavin's
Hold on.
bringing that up,
Let me share this first, Lisa, before we go in. We'll
So
go
when
ahead,
they're
Todd.
messing with your tax records, they're violating 7201 and 7206, right? They're doing tax evasion and they're concealing your accounting records from you. You see all those
Attorneys and
cases.
accountants.
Yeah, and you
Like-
see all those cases right there. Those are all the ones that the IRS used against the attorneys and the judges doing this kind of stuff. That's just a basic list.
Oh,
They
so this is
are
the
liable.
enforcement.
That's the enforcement through the IRS. My dad actually was, he defeated the IRS twice because my dad was on the forefront of telling the attorneys and the judges that you better have your client's money in a trust account, like separated for each person in a separate trust account. So the Bar Association eventually adopted that, but it took a very long time. It took a lot of attorneys going to jail and prison for embezzlement before they force the trust accounts onto people. But this is generally what they're doing anyways with the securities. So what ended up happening, and I still have to defend this every now and then when my mom needs a loan because the IRS is so pissed that my dad beat them twice. They were saying deposits into his business account was income. And my dad's just like, no, it's not income until I transfer it to my personal bank account. It is a trust account to be drawn upon by the client when necessary. And so the IRS is trying to say that that was business income and it was personal income at the same time. And so he defeated them in court twice. And the IRS was so mad that he beat them on the accounting that forever those two court cases still sit as a lien on my mom and my dad passed away, but it still sits as a lien on their records. And the IRS, my dad petitioned the courts repeatedly to remove the lien because he won the cases, and the IRS refuses to remove it because they're so mad that he beat them with accounting.
Okay, so you
he was
learned
well versed on the accounting side. Well
I see.
versed.
So that's how you saw your dad win on these two accounting cases with the IRS,
Yes.
and that really at that point you learned that this strategy worked
Yes.
to
They
enforce.
can't get around the accounting, and you can't lie about it. You can't conceal it. And then since the Enron case, you can no longer conceal the accounting because the U.S. Department of Justice got busted for that.
All right,
Enron
what
got busted for it. So
before I go back to Lisa, can you tell me about the Enron? I mean, I have a different perception on the Enron case than what you had. So what's the deal with the Enron case?
the Enron case, what ended up happening is Enron, the corporation, they were selling power systems to Africa, and they were claiming that there was problems with accounting. And it turned out that Enron was doing their accounting properly, but the Department of Justice was trying to say they were responsible for the accounting for the people that were buying the power systems. That's not true. So Enron, the corporation, was acquitted in the appellate court because the Department of Justice basically lied and concealed the accounting records and lied and concealed the testimony of the people internal at the accounting department, right? So the four Department of Justice tax attorneys and prosecutors, they all went to prison over the concealment, over the Brady violations, and one of them committed suicide the day before sentencing. So even though they got the Congressional Medal of Honor from Barack Obama, they all went to prison. So that should have been revoked. That should have been more public news. And then what ended up actually happening is Kenneth Lay went to prison for securities fraud and for tax evasion because he had a TTNL terminal at Enron. And I have a copy of the transcript of the MoneyNet Daily Transfer Log 120. He was using his terminal to move credit from the minor account to his Bank of America bank account and not reporting it as income. He got nailed for tax evasion.
That was the actual crime.
That was the actual crime. Kenneth Lay using his TTNL terminal to move credit and create an accounting transfer, a deposit into his Bank of America bank account.
Wow.
Right.
Lisa, did you want to add something?
Sure. What I think, Todd, I think would be great is not only an introduction to the movie, but I think that those that may view this, because it is going to be public, is let's go back to the very basics and explain that for every court case, there is a deposit underneath the 28 USC 2041, and
Yes.
that they create securities without you knowing it and without you granting permission. So can you
Yeah.
explain a little bit more about that and then why the gap accounting comes in? So can you do it in two parts, the
Yeah.
first and the second?
Let me get a record for everybody here. I'll drop it into the comments. Just give me a second. It's going to be the 1099 A and C instructions from the IRS. A and C, because this is going to blow it out of the water. Here's your proof. Because you're not going to find the proof anywhere else that they're doing this other than they have an administrative agreement with the IRS that authorizes them to do it, okay? Okay, let's see, desktop.
I have, do you want me to, are you having a hard time pulling
No,
it up? I have it.
I've got it.
Okay, good.
I just got to see where I put it. Here we go. Okay, so Gavin, if you want to put that up on the monitor for everybody.
Yep.
And believe me, I've been in front of state clerks of the court, federal clerks of the court. They surround me with sheriffs, they surround me with U.S. Marshals. I don't care. I literally look at them and I say, I'm here to make sure that the clerk of the court doesn't go to prison. Here's my documentation and my proof that they're actually doing this, right? So I'm here just to get documentation from you, which is required by law under the Internal Revenue Code. So if you scroll down to page 3, and we're going to go to section section 5 on page 3. I think we went a little too far. We're on page 5.
Okay, page
Down.
sorry. Page 2, page 3. Here we go. Oh man, this thing goes fast.
Page 3. Yep. So number 5C. Oh my gosh, who's filing a 1099-A? A court or court administrative office. So a 1099-A is proof that they have acquired your secured property or that you have abandoned your property. You've abandoned your bond. So the 1099-A also has to be coupled with a CUSIP, right? So that's the tracking number for the bid performance and payment bond that's in the CRIS system, Court Registry Investment System. And so, yes, they have created a bond. There is a CUSIP for it, and they use the 1099-A to extract the credit from your minor account to fund the bond. Okay, so, and there's plenty of stuff in Title 31 with the Treasury Department that says they're authorized to do this. If you really want to hunt for it, I have that too. So yes, they are actually doing it. There's your proof. What else do you need, right? How much more proof do people need that they're concealing and removing the accounting and the securities from the court, which is a violation of 7206, right? 7206 from the Internal Revenue Service. They are removing the accounting and the securities to defraud you as the grantor, bailer, owner, and beneficiary, right? And that is a trust. Securities are held in trust. So when you revoke and revest it and they don't liquidate it, now they're into embezzlement. They're operating as what is called the incidental beneficiary committing defalcation. Okay, that means that they're acting as a beneficiary to that security when you're the beneficiary. Defalcation means that they're embezzling it from you.
So Todd,
These are legal terms that the IRS uses for this process of them embezzling the securities when you've revoked and revested.
You mentioned earlier someone who was well known. A lot of us have heard of. I mean, Gene Keating. I guess maybe. What's the story with Gene Keating? How do you know him, or who is he?
I know him because I worked with him a little bit on certain specific topics because he's obviously probably the nation's leading expert in bonding, underwriting, securities, uniform commercial code, and how the entire process works with the court because his two brothers are also federal judges and they essentially ratted out the system. So Gene Keating had a document, I think it was called Cracking the Code, if I remember right, which he explained the commercial nature of the courts, and he pulled out all the case law, statutes, codes, everything that they were using to operate the court on the commercial side, right? So I do have a memorandum of law for that. I do actually train judges and other attorneys that need training. So I actually handle the bonding and underwriting commercial securities and their liability for what they're doing when they get caught.
Now, I saw on your LinkedIn, you have a number of I mean, you like a lot of things I didn't understand. There was like DTC and a lot of these things. Can you go over your background a little bit on what you're?
I mean, my original background is I was a chief information officer in the pharmaceutical industry. So I have advanced degrees in biochemistry and immunology, and then MBA, and then worked through the JD and things of that nature. Geared toward just doing the trust stuff because when my dad was getting older, somebody needed to take over the trust. So I had to learn that side a lot more effectively. And then it got to the point where I was having to sue banks, right? And having the internal knowledge of how the banks work and on all the mortgage fraud and stuff like that that's going on. And it's the same thing. The mortgage stuff is all a trust. It's all accounting fraud. It's gas violations. But because of my background and what I did with forensic auditing and things of that nature as a forensic auditor and consultant in that arena, to the big real estate companies, the big brokers that are doing mortgages, Berkshire Hathaway, I consulted with them for 10 years. Douglas Elliman, Prudential, Remax, Coldwell Banker, all the biggies, right? So I was brought in at the corporate level to explain to them how to use a trust to protect their clients and how to understand what's going on with the mortgage and the securitization of the paper under Article 3 and Article 8 and 9 of the Uniform Commercial Code. And that it's all about the accounting and the trust. And then you start eventually running into people that work in the equity realm on Wall Street and they fully disclose to you that, yeah, they're selling that security. They're not doing a tranche anymore where it's like 50 pieces of the security. They're selling the whole security 50 times. It's insanity what they think they're getting away with and not paying taxes on that. And then you eventually ran into IRS Criminal Investigation Division people that were mortgage fraud investigators who their job was to actually audit the courts and the banks and to fine them for all the violations. So that's why I also put earlier, I put like one of their, did I put that in here? Yeah, I put the violations as like very first thing in the comments. If you wanted to pull that up, that's the basic list they hit them with.
Yeah,
So
that
this
was
applies to the courts and the banks, because remember the court is a bank, right? They're selling private commercial securities, so Gap and Gas applies to them.
this one.
Yeah, no, the very first one, 091 violations, the very first one that I dropped in the comments.
Okay, I'll have to grab that one. So
So yeah,
back to
that's
while I'm
how I
looking for
kind of
that.
run into all that stuff is you start to have to learn and understand what they're doing, and everything's in trust. And as soon as you understand the basic concept of a trust, that you can revoke and revest anything that's a revocable trust and collapse it, and then they go on the run. Then they start concealing stuff, and you start finding out they're lying to you, and they won't disclose anything. Well, guess where they can't lie about the accounting? U.S. tax court. Right.
Violations.
This is the basic list that the CID goes after when they're auditing a court or a bank.
So you're
How many-
saying that the court has
The
to.
court, yeah, the court has to keep their accounting. The court took the accounting out many, many years ago because people were collapsing court cases very easily because the judge had a terminal. The judge had access to the accounting. So they removed the accounting from the court so they can play dumb. Right? Plausible deniability. We've never heard of this before. Accounting, we don't have any accounting records. Well, that's because you violated 7206. This is fraud and false statements and concealment. You removed the accounting and the securities from the court to defraud me. Those things are a trust. Everything in this court is a trust because it's an administrative court. It has to be dealing with a trust somewhere. There has to be a bond somewhere. You're administrative. You cannot get around this. This is how you're structured.
And there was I'll see if I could find it. There's a funny video that I saw that on your LinkedIn page about a guy going into court and then he left his camera on and then the judge was talking about, you want to talk about that?
Oh, yeah. That was for a case that we collapsed. And so the lady was in the courtroom and she revoked and revested in the courtroom, did everything she was supposed to do, equitable subrogation, discharge, and the judge flipped out, the prosecutor flipped out. And so after she left for the day, because they wouldn't do it, which is now a felony, so she's going to U.S. tax court now. The prosecutor was sitting there disparaging and bad-mouthing the IRS. And so I sent a copy of that to the IRS Criminal Investigation Division, and let me tell you, they are hot. They are just like, you do not revoke and revest, and then you guys sit there and embezzle everything and then badmouth us. They're just like, we're coming for you. We know who you are. We have your picture. We know your name. You are going to be audited.
Whoa.
Yep. Don't mess with the IRS. When you revoke and revest, do not mess with the IRS. They are coming for you. And those are some of the statutes and issues they're going to use against them. And you see all that case law they're going to use against him. Right? That guy's going to prison.
So has this ever happened? I mean, I obviously I saw those other cases. This has happened before with a lot of these.
You saw the cases I gave
Yeah.
you. The IRS
Yeah, you
uses
did.
those against them. They're going to prison.
Right. That's all these cases here.
That's straight out of the IRS's own playbook. Yeah, so like I said, it's like 1,200 pages long. I have it.
So this is just the one about, oh, the attorneys. Yeah. Whenever
Yeah.
the attorney does that.
Yeah. So remember, 7201 is tax evasion, 7206 is concealment. Government lawyers, right? Criminal defense lawyers, tax lawyers, real estate lawyers. Yeah. You don't get to conceal the accounting anymore.
Right.
They're done with you people. After Sarbanes-Oxley and the whole Enron debacle, they're done with you. You can't hide the accounting anymore. So what we're seeing now is when you go into the courts and we basically specifically state, are you striking or denying Sarbanes-Oxley and the Securities and Exchange Act? And they say yes. Say thank you very much. That's a willful felony. You have no authority to or plenary powers to strike an act of Congress. This is how arrogant they are. They don't think the IRS is coming for them. Because too many people have threatened them with Form 56s over the years, and the IRS never showed up, or 211s and 3949As, because you got black hats inside the IRS that won't charge it. So that's why I'm telling people we're at the stage now where they're so arrogant that we just have to file key tam in U.S. tax court, but we have to ramp up the documentation to prove that they embezzled from you. When you revoke and revest and they don't liquidate that trust for you and do the discharge like they're supposed to, that's willful embezzlement. It switches from a civil issue to a criminal. So you have to understand Internal Revenue Manual 25, I think it's .1.3 or .1.3, and then 9.1.3, which is the criminal statutes that the IRS uses for the 7201 and 7206 violation. This is what they're doing. They're broke. They're embezzling. They don't have any other choice but to embezzle. Remember, they were told after the whole Enron debacle and the mortgage housing collapse and stuff like that, that they set everything up to do a bail-in, right? Well, they're so scared about people found out their plans to do the bail-in that now they're just straight embezzling. They're just straight doing 1099-As. So they're not doing necessarily a bail-in. I would say they're doing a bail-in from the Treasury Department because they're using their terminals to go after the Treasury and just move ones and zeros, do book entries everywhere. No commercial paper.
Todd, I saw that it says you're registered with the IRS and DTCC. What is DTCC for people?
The Depository Trust Clearing Company. So all my securities are registered with them. So basically, they know nobody's supposed to be touching my securities. So when people do things like they did 2 months ago and did 2,500 1099-As, that's why I flipped out at the IRS and said, I'm going to find out who did this. I'm going to pull that individual master file and they're going to get charged. Get off my minor account. Stop doing tax records for me. You're not authorized. I have all my stuff filed with the Social Security, IRS, DTC, all of them. I have all their own forms, their own statutory forms. Tell them, get off my account. It's locked up. What are you doing in there? Who gave you authority? You don't have power of trustee. You don't have power of attorney. The agency agreements are terminated. I filed all your forms to stop all this stuff. Who's letting this go through? All this stuff. And I contact them. They say, yeah, we can see that in your records. And I'm just like, then who's allowing it? Why are there no safeguards in these terminals to say that account is locked? That is the problem. The TT&L terminals are so old, they don't have any safety mechanisms to show that the account is locked. And whoever's doing the pull isn't checking the commercial records, and they're not double checking their agency agreement to see if they're allowed to do it or not. They're just straight doing it. And like we said earlier, they're doing it with no securities license because they can't get licensed and bonded to do this. It's illegal.
Here's the website for the movie. I saw Sabrina, you asked about it, and it's going to be on the Thanksgiving Day. Link will be posted on here on November 27th. BirthRightMovie.com. BirthRightTheMovie.com. And it's got a lot of people.
So does that mean it's only going to be streamed on this day on Thanksgiving, or will it after Thanksgiving will we have access?
I don't know, but it's just a new movie. So I think they're doing a preview here on this website before. Do you know, Todd?
When it's going to be streamed?
I know it's going to be streamed on Thanksgiving. I'm not sure about after that. I think it's a premiere.
That's Lisa's question.
Lisa, I have a question or a suggestion. Are you familiar with Angel Studios?
I am, and I know that they're trying to get this because they've now been through the Independent Film Festival and they've picked up some funding, and so they're releasing it. I think it is a pay-per-view, and so is that what you're asking, Sabrina? If we can get the link that you can watch the first section of the Birthright movie?
Yeah, well, I think the link was posted, but I have a client who works for Angel Studios, and he told me because I talked to him actually, I was asking if they showed this birth movie, and he said no, but it sounds really interesting. And he gave me kind of like the formatting to go through to get the movie approved. And it could be because Angel Studios is a streaming, um, they're a streaming, I don't know, company. And so but it's all like there's it's all very conservative valued, and any movie that's put on there has to be voted on by the board. And so if that's something you're interested in, I have a connection there at Angel Studios. I just met with them last week.
We can definitely forward it on to the right people. So we really feel like everybody should see this. And what I think is my personal, testimony about this movie is I've studied this for 30 years. And after I met Todd and, I wasn't afraid anymore to basically stand up. When you start looking at um, they're charging basically your corporate entity for administrative or crime. They call them crimes, but what I'd like Todd to talk about is, if you're in court and you're asking the nature of the accusation or the nature of the charge and what jurisdiction they're falling under and the fact that they're creating securities on your behalf, we have to all look at ourselves as they think that we are the battery. Like I know we're going back to the Matrix, but it's a way that people can understand it. And so we have been teaching people to document, even in an Excel spreadsheet, every single thing that we think that we've done in commerce, from your driver's license, your birth certificate, your passport, your every court case you've ever opened, either been a plaintiff or defendant of, every traffic ticket. When you really look at this, we did it on my family. And what I was shocked when we traced even our kids, their student IDs at the university had CUSPID numbers. They're committing fraud every single day. And they're also, because if you go back to the Constitution and you look at the protections that we have a right to a jury. These administrative courts, 99% of them are done through plea bargains and they're done through, basically
Or
summary judgments or others.
they'll force a bench trial on you, no jury.
Yep. Lots and lots of elements. When you start picking the scab of this problem, it's a bleeder, it's a gusher, and you have to learn to absorb like really what is happening to the commercialization of the human being. It's alarming, and so this movie brings out that nature of it, but it also talks about the bonding. It talks about all those elements. But go ahead, Todd.
Yeah, it does talk about all that. And like Lisa was talking about there, I dropped into the comments for everybody, your basic like court appearance, whether you're appearing, in an administrative court, and the types of things that you need to say while you're in there because you have to catch them on certain jurisdictional issues. It's to the point now where you go in and you ask or you even put a memorandum of law around the Sixth Amendment nature of the accusation, they strike it. How do you strike the Constitution in a traffic court? Right? They're basically know they're just setting themselves up to lose, right? But what do they want you to do? Appeal and open another bond so they can laugh at you, right? And they're striking equitable subrogation. So you're just like, there's nothing else. It's an administrative court. We're dealing with the accounting for the securities. So this is the kind of dumb stuff that they're doing. And they're making it progressively more worse because of the people that have figured it out. So I also dropped into the comments there a UCC filing that I have, it basically discloses to everybody on the commercial side the private power of attorney revocations that I have with the different agencies using their forms to let everybody know, get off my records, get off my tax records. Okay, what are you doing in there? Everything is blocked, right? Everything's registered. There's a lien on everything. And if you create a trust for me, you create a security for me, I'm going to take you into U.S. tax court for fraud, right? Giving them public disclosure, public notice, because if these agencies aren't going to put a block on it, I'm going to put it out in the public domain. There's a block on this. These agencies have copies of these forms. You're not supposed to be doing this. Right? This becomes a very powerful exhibit in the court to look at a prosecutor and say, how did you step through my these powers of attorney that were revoked? So this isn't the whole thing that Mr. Straight was doing, revocation of election. That's a notice. That doesn't do anything. Notice does nothing. When you're in the statutory realm and you use their forms to block them, now they're not following their own statutory rules, are they? And you've got liens on everything. You've given them notice of what they're doing. They're creating securities.
Yeah.
Right.
And I'm going to go to
So
Catherine with
they're-
your hand
so
up.
they're
Before I do that, let me
not-
just comment on notice really quick. That's a really good point that you made, because I think a lot of people who have tried to go to court or do patriot stuff, what they do is all these notices. And notices are just notices. That's all they are. They take notice and that's it. They have no enforcement. So
No.
that's the big difference.
Yeah. Now, when you understand equitable subrogation, right, where now you're throwing your debtor under the bus to discharge the liability, now you're throwing the liability back at the court to do the accounting. And if they don't, and you revoked and revested that trust and the accounting, and they don't do it, that is a willful criminal act of embezzlement of your estate funds that are there for equitable subrogation.
Catherine.
Right? They cannot, they try to get around this, but when they start denying equitable subrogation, they strike the Sixth Amendment, they strike Sarbanes-Oxley, Securities and Exchange Act, strike the Federal Reserve at a lower court level, a state court or lower. This isn't no congressional authority. This is ripe for U.S. tax court, right? Ripe for U.S. tax court. Absolutely.
Todd, can you talk a little bit about your quote administrative process, which when you ask for the QSIP, is there something more to that, or is it just
Well,
getting?
yeah, that's fraud and false statements and concealment when they don't provide it. It's a Sarbanes-Oxley violation under 7206. You go into U.S. tax court. You don't want to provide it. I'll go to U.S. tax court and get it.
Okay,
Right.
so when you do get the QSIP, the administrative process is forcing the court to give you the accounting.
Yeah, forcing the court to admit that there's a bond and that we need to do the accounting for it. We need to cancel and discharge it. So you file this is a setup, okay? The administrative process is a setup for a willful criminal act of embezzlement and tax evasion, right? So you file the A, you file the C, you cancel and discharge it. Then you look at them and say, hey, all this stuff is sitting on your books. Why aren't you guys filing taxes? That's a 7201 violation, 18 U.S.C. 357, right? Aggravated identity theft, tax evasion, all kinds of stuff. So I'm letting them know, here's what you guys are doing. Get off my records. What are you doing? Superseding the form that I signed and put into your agency. Where did you get your authority from? I revoked it from you with your own forms.
So what happens
if I send you a notice? I sent you your own forms. Get off my records.
So if you're in the middle of a court case, say like I had an administrative hearing, now I'm in a writ of mandamus and I'm about to go into a demur hearing. Say I bring it up in the demur hearing.
Yeah, why are you arguing case law? The only issue is the accounting.
So what if I bring it up in the demur hearing?
You can.
Does your administrative process include coaching on that?
Coaching? Yeah, because like I did with the how to appear in court, that's what you're going to be doing. Once you ramp up all the documentation through the IRS side, the only thing left is the accounting.
Okay, is that in that quote you gave me for 3,000, or is that some different
Yeah.
price?
Yeah, that's part of it. Yeah, that's part of it.
What say I'm, can pull everything off. What's the expected result?
It depends on how far the court wants to push it and how arrogant they are.
Okay.
If they're being completely arrogant, right, we take them in U.S. tax court.
Okay. say they aren't.
This is what they're afraid of, because when you revoke and revest and they don't liquidate and handle the accounting and they don't do the equitable subrogation, they're screwed. They're going to prison
Okay.
because you're going to document this in U.S. tax court, all the violations that they did. They can
Okay.
be, there's no, remember, there's no arguing. So just like they say, you can't argue the statute or code violations that you committed against them. Do you think they can argue the statute and code violations they did against the IRS? No, because the
Mm-hmm.
case law is against them. There's
Mm-hmm.
nothing in their favor that says they can do it.
Okay.
It's the same thing. You're tipping the scales back onto them.
Okay.
Okay, so if they created a 1099-A, you think they're going to go into the IRS and say we didn't do it?
I don't know.
You're guilty. You did it. Here's the QSIP. Holy shit, a 4506T form. Let's pull the 1099-A from the IRS. I've got copies of ones that people have gotten back from the IRS. It takes forever to get it, unless you got people on the inside.
Mhm.
But yeah, they can't say they didn't do it. Here's a copy of it. Oh shit, you filled it out wrong. You made me the borrower and you the lender? That's tax preparation fraud.
Mhm.
So basically,
Uh-oh.
Todd, what you're doing is, it sounds like, is everything in the movie is the background of like the story and what happened and how they commercialized everything, right? Because
Yeah,
you said they commercialized all these
they do
instruments,
everything. Yeah, they do everything backwards. They make
right?
you the borrower and then the lender. That's
But
fine. Even under
you
Title
don't
12
need a
of the Federal
hearing.
Reserve, they say that you're the lender. They're the borrower. Federal Reserve says so. I'm going to go with what the Federal Reserve says all day.
Do
Hmm.
you need a hearing to enforce this, like an upcoming
Yes,
hearing?
you do need a hearing to enforce it. You have to go in there with your documentation in advance, right? And then you have to go in and, force the equitable subrogation by discharge.
So
And if they
you
don't
have to
do it,
have a
if
scheduled
they
hearing.
don't do it, you're going to U.S. tax courts, and you don't even have to ask. You don't have to remove the case. You're automatically filing key tam the next day. You're
Mhm.
charging them criminally. You have the evidence. It's in the court.
Okay, but what I'm asking is, I'm trying to figure out like the bullet I want to discharge is I have a demur hearing coming up.
Yeah.
If so, I have two paths. See if he grants the writ or to use the demur hearing to do this, because if he doesn't grant the writ, then he may give me another opportunity to amend.
Is your writ for equitable subrogation and
No,
discharge, closure of all accounts,
no,
or is it something else?
something else.
There you go. They're going to deny it. Now
Oh,
your writ also has to include, if you're going after the bonds, you're gonna have to give their violations. 7206 is a violation, isn't it? Fraud and false statements and concealment under the writ. This is right for appeal. And I'm not even appealing. I'm not going to open another. You can tell the judge, I'm not going to open another bond in the appellate court. I'm going to U.S. tax court. You
mhm.
just violated 7206, fraud and false statements and concealment. This language is so easy to read, right? A sixth grader can read this. You just concealed the accounting and securities,
Did you
right?
want to share something on the screen, Lisa? Go back to that.
Yeah, I think what I was trying to say is everybody needs to understand that not only your birth certificate or your social security, the FRAN number, these are all QSPIDs. We've traced
Yeah.
100% of them for our family. So this happens to be my birth certificate, and the number there is a QSPID number. And I think that it's very important for anybody listening to this that, a lot of us identify with not only that birth certificate, but I really encourage you, and this is what Todd has taught me, which has been phenomenal, is go out to the statute. Todd always gives the statute. Go read them. When you read them, and it's like they're using colorful words in colorful admiralty, and you look at their definition of a person, you look at, who owns those things. I mean, when you really start doing your homework here and you go down this Alice in Wonderland, event, I don't like the straw man either, but in every court case, and I have seen this and personally experienced it, where you'll notice your name in various forms. Your estate, your transmitting utility, which is just your middle initial. And if you're dealing in anything criminal, you'll just be John Doe, like they're just going to do first name and last name. Every single one of these are corporate versions of yourself. And do you have to admit to who they are or what they are? And we've done a really good job of trying to educate our children of, knowing the difference. And through the equity subrogation, which we're talking about, if you are being asked on your, even what they're doing on the identity theft on the Social Security, again, it doesn't belong to you. But can you further explain, Todd, even what it means on equitable subrogation? Because as you look at the fact that that is a trust and how you reclaim that, what that means to be a secured party creditor or holder due course, what it means when we look at how they're using colorable terms to assume that you're the debtor and automatically assign a contract that is beneficial to the United States.
So let's take a look at equitable subrogation. Okay,
Okay.
so what that's talking about is it's about securities, right? Because there's always a security somewhere with equitable subrogation. So that's the court bond. And what you're doing is you're throwing your estate under the bus. You're saying, I'm going to throw this thing into the mix here, your estate, your legal fiction, and that thing is going to replace me, and it is going to do the discharge. So they charged your estate, right, with the charge, the revised statute that you violated. So they charged you, and then your estate is responsible to discharge it. So while you're in the courtroom, they're assuming that you, as the living man or woman, is going to discharge, but you really can't. Only your legal fiction can discharge. So when you do equitable subrogation, that thing gets thrown under the bus to do the discharge, and you order it to do it, right? Now, the interesting thing that comes into play is now the judge has to do the accounting, has to adjudicate and pay the creditors, right? So the state basically is saying they haven't been paid. Well, yes, you guys got paid because everything's prepaid without recourse, because we don't have money. We have money of account, not money of exchange, because of the bankruptcy. So the state has actually already been paid, and they're lying to you, and they are not doing their accounting. So it's a 7201 violation. They don't have a matching ledger. I've talked to plenty of clerks of the court and finance officers at the federal and state level, and they always tell you the same thing. We don't have any accounting. Well, how did you do the A if you didn't do the accounting? Did you not ledger a credit and a debit or an asset and a liability? Are you doing no accounting whatsoever? That's fraud. You're contracted with the IRS. You have an EIN number. You have a contract with them to do it. Right. And so they get scared really, really fast because they do have the accounting, but they're concealing it, and they won't let you get to it without going through the IRS. So equitable subrogation is where they're supposed to do the accounting and do the discharge, set off, and what you want them to do is close the accounts, right? Close everything down. That means cancel and discharge, right? That's the A and the C. You do it for them, the A and the C, and then they freak out because now they're into willful failure to file a return, a 7203 violation, okay? Now, when you're a secured party creditor and they're doing the equitable subrogation, anything that's left over, do they not have to give it to you? Oh, yeah, they do, because you're first in line, because they don't have a UCC lien, but you're agreeing to take some of the money that they took to pay them for the alleged crime that you committed that has a commercial value to it. And what they're trying to do is during the equitable subrogation, they want to pay the state and pay everybody that's supposed to get paid, the sheriff, the prosecutor, but then they want to keep the rest of it. Well, if you're already a secured party creditor, they got to pay you first, right? That leaves them with nothing. They made no money on this entire transaction, none whatsoever. Now, you could also argue that I'm a secured party creditor. You stepped in front of me. How did you do that?
So that seems like that's the remedy.
Everything.
The equitable subrogation is the remedy.
Equitable subrogation is the remedy because that allows us to step beyond the statutes and codes and policies and procedures into the equity realm, right? And handle the accounting, because now we're just saying you guys have created a big giant mess. There's no way to really unravel what you've done. So go ahead and zero out this bill and dismiss the case with prejudice. And now I'll just go handle it at the IRS. I got the A and the C. I just need the accounting from you, and then I'll file the B. But you got to give me the real accounting. And since you don't want to give it to me, I'm filing fraud with the IRS because you won't give me the real accounting. And the IRS, guess what? They have the terminals, so you can file the B and ask for a check back, right? And then the court gets stuffed with having to pay the IRS back. because the court's going to get a copy of the B, aren't they? Showing that they had to pay you. So instead of the court paying you, the court's going to pay the IRS back.
Lisa,
So
did you have your
I
question?
think you had the scenario with Q, right, where the court tried to give him like a $40-something thousand check as a novation. He said,
And what happened,
it's
Lisa? You want to tell
certified
the story with
accounting.
Q?
I would be happy to. So, Gavin, I know that you have taught very much so to try to do a CMA, with them. But when my son was wrongfully arrested, and we could have gone Title 42, we could have gone a lot of routes. But what I did is we just pulled the cuspids on the case. We canceled them. We actually did a FOIA request, actually three separate FOIA requests. One was to the risk management department of the state, because they have to approve anybody that is bringing a case against someone. And then the second thing, and I apologize, my dogs are going to bark in 10 seconds. Hold on a second. Thank you guys. Sorry, my son just came in through the door. So, as part of that, what we ended up doing is we traced the cuspids on the case and we FOIA'd them to the risk management department. Then we also FOIA request to the or in Oregon, all of the CRIS securities are created in a central location, and we found that out because of our FOIA request. We asked the clerk of the court for their EIN number, and they gave us an EIN number. But when we asked risk management for who filed the securities, the EIN number they gave us was also, and the name was the department. It's State of Oregon Judicial Department of Business and Fiscal Services. So this is what Todd was talking about, is that they have plausible deniability. So the clerks of the court and the judges are not doing the securities any longer. So typically the state or a comptroller or business and fiscal services are doing it, or if it is a federal case, there is a central group that does that. So once we FOIA'd them, we also FOIA'd them for the 1099A. We filed the IRS forms for the 1099As, and the courts will definitely gaslight you, and that is what we have found. So then what we did is a UCC filing on the accounting, not against the judges, not against any administrators or anything.
Let me stop you right there, Lisa. Everybody that's on this call, do not ever lien a corporation or a person without a court order. That is a felony. You lien your property and you list the people that stole your property in the collateral section, as these are the perpetrators that did this. You put them on public blast. You're not liening them, you're naming them as the people that created this problem.
Yeah, so when you fill out a UCC, there's debtors and creditors. So the agency itself the agency can be named, but not the individuals, because these guys can charge you with a crime. So we did do a UCC on it. And then when they refused to provide us the accounting, we did a 1099-C and canceled the security. Now, for my son's case, what did they do? They doubled down. They said, I am not giving you a CMA. I'm not giving you remedy. And as part of that process, the first thing that happened is he did get a $40,000 check, and we sent it back and we said, we're not accepting contract. We're not accepting any new terms of novation. And then he got a second check, and we don't even know, because it doesn't match any of the accounting. Neither of these matched any of the accounting. So then he got a $290 check, and we sent it back too, saying, we don't even know what this is for. Like, we're not accepting any novation. We basically filed for the accounting. Give us the accounting. But they will send a check, and at the moment you cash that check, and we've had this happen, then they're done because you accepted the term of novation.
Yeah. So term of novation is also sometimes called an accord and satisfaction, UCC 3-311, where new terms and conditions have been settled by the parties and there's nobody's guilty. Everybody's off the hook.
So, as part of this process, what I have learned from Todd and their family is number one, we've gone through the process and done a secure party creditor, holder to course, and a complex trust. We operate in the private. Like, you have to learn to operate in the private. If somebody's trying to bring you into the public and they're filing these things against you, the thing that you can learn from this movie, as well as Todd and those that are doing this correctly, is this group in particular, and I know this is going to be made public, but this group can learn how to take control of those things because they're committing crimes against you every time.
And that's why the best thing ever is last week when one of our clients was in U.S. tax court with a $450,000 tax bill under the discovery request in U.S. tax court. We listed the QSIPs and we revoked and revested and listed all the crimes that they had committed under the Internal Revenue Service. And the judge and the prosecutor for the Department of Tax, the Internal Revenue Service, they did not appear in court and case was dismissed. And so this was actually being led by a gentleman, I won't say his name, but it's been led by a gentleman who's been beating the IRS for 35 years and has discharged more than $500 million in tax cases in 35 years. He said he's never seen anything like this. He said, I absolutely blew them out of the water. He says he's never seen in 35 years the judge and the prosecutor not appear in court. He says you always have to fight him for a little bit. He's like, this is the first time we hit him right out the gate and it's done.
So anybody want to jump in and ask any questions or comments? Now would be a good time to open up. I know there were some in the
Yeah, I have one.
chat there. Who's that?
Catherine.
Catherine, yeah, go ahead.
So when you say by accepting the check, it's accord and satisfaction, does that get Q's, would that have gotten Q's case dismissed?
No, because they still made him go through the process, but he was doing the administrative remedy on the side, and they were trying to settle the filing of the QSPID. So there was three things that happened on his QSPIDs also is they changed the charge and the charge created a new the change in charge created a new QSPID. And then they changed judges and it created a new QSPID. So you have to be very cognizant of it. So he refused the checks and sent them back and he demanded the accounting. And then we've entered into now doing the second step of actually the accounting fraud. So,
So they're essentially still leaning your minor's, your estate, your minor account. They're not dismissing the charge. They're giving you some money.
Yeah, so
but
here's what happens. If you file the 1099 A and C and you cancel and discharge the securities, the court never files the A and the C on their side. They think they're an exempt organization. They don't have to file. That's false. That's false. When they get the A and the C, they have to cancel and discharge and let the broker know to cancel the securities. Right? Now they don't do that. So even if they dismiss your case with prejudice, they're still selling your securities. Right? So if you have revoked and revested and they're still selling your securities, you are owed all the interest, profit, proceeds, rents, everything that's generated from that. Now you can go after them in U.S. tax court because you revoked and revested, and now they owe you all that money.
will they pay all that money?
You'll get it in U.S. tax court, right? Because they'll have to settle with you there because they can't, the U.S. tax court, what can they not do in U.S. tax court? Not disclose the accounting. You are there in U.S. tax court only deals with accounting. It cannot be like not disclosed. And if the agents in U.S. tax court don't want to disclose it, 1203B1 violation, we're going to get you fired. Your job at the IRS is to audit taxes, audit the books. If you don't want to do it, and we've reported a crime, in this case, a case that's been dismissed and they won't turn over the accounting and they're still selling the securities, my God, somebody's going to jail.
Wow. Okay, looks like Sabrina Max has her hand up too. So did you want to chime in, Sabrina?
Yeah, I have a question. So I had an opportunity to go to US tax court. I asked the judge and the clerk and the attorneys that they would sign an affidavit saying that it would be fair hearing and, innocent until proven guilty, all the good stuff. They did not want to. They said, you pay $60 or you can't come to court. I chose not to pay the $60. And then I found out later that the attorney on the other side filed false paperwork, false signatures. And I went back to the tax court and said, hey, this is happening. I'll pay the $60. I want to get this, on the record. And also, I didn't know about their portal, the Dawson portal that they were using, because I was never instructed to go there to check documentation. Make a long story short, the judge declined my request for a rehearing and to reopen the case. And so I'm wondering, are there any effective remedies that could be applied so that I can get back
what do you think's going to happen when you send a motion order to revoke and revest and you got the QSIP and the A and the C filed in a lien?
Well, I guess that's the remedy then, right? That's what I've got to do.
Yeah.
Okay.
So the QSIP tracing is about between $100 and $200, depending on who you can get to pull the QSIP. You have to then, again, Todd, talk a little bit about the A and the C.
So
And
the A and the C, so the A has to be corrected first, okay? The problem with the QSIPs is we can get the major pool, but they're never going to give us the minor pool because it's under the Bank Secrecy Act. So you never know the exact accounting. And the exact accounting changes on a regular basis as profit interest is reported to the IRS. So that's why you'll never really get the individual dollar amount. It's up to the IRS to audit. So the A is to basically correct their filing, because remember, what did they do? They made you the borrower and then the lender. So you have to correct it, and you have to make yourself as the lender and then the borrower responsible to repay the debt, and you have to audit, right? The 7201 code is for audit. So that triggers the audit with the IRS. And then once the IRS accepts the A, then you file a C and you cancel and discharge with the exact same information. And now here's the rub is they're not going to get audited unless you force the audit with a bunch of different documentation through CID, because the court does not think that they are required to file the tax records. They think they're exempt government organizations, so they never file the A and the C to trigger the audit, right? This is why you're ramping up the documentation on your side to go back in through CID, through the front door channels, and then come after them. And you'll basically file a key tam criminal complaint against the tax court judge, the clerk, and the prosecutor in the case. So you're going to come back around after them in their own court. Watch what happens. They're not going to show up. The case is going to be dismissed, vacated.
So you said, Todd, to Sabrina, that if she were to revoke and revest, what do you think is going to happen? What would happen in that case?
They're never going to show up in court. They're embezzling because you're using the revoke and revest codes for the trust, for the securities in the IRS court, and they're not allowed to not reveal the accounting. That would be a violation of Sarbanes-Oxley and the Securities and Exchange Act and 7206. So that's why I showed you that list is what the IRS uses against people doing this. Right? That list of 33 items, that's the basic core list that every single court and bank violates every single day. That one.
And something that is important is we tried on Q's case, my son's case, we tried to subpoena the fiscal services and the comptroller, Elizabeth Stein, who is here in Oregon. And immediately the state attorney did a motion to quash. They don't want to appear in court. They absolutely do not. They will do anything and everything to avoid appearing in court.
Can they quash accounting in a tax court?
No.
No.
That's the only place they can't do it.
Tax court. I don't know anything about tax court. Sabrina, you've been to tax court before. You said you didn't. How did it go for you?
Well, I was told that they didn't have any jurisdiction because I wouldn't pay their $60 until I got,
Pay the
something that
pay the $60 and pull the QSIP and go after them.
That's what I'm going to do now. because
Yeah.
I did try to give them their $60 again. They said, no, this case is done, but I'm gonna do that. I'm gonna use
Well,
your remedy.
the case isn't done. The QSIP is open. They can say it's done all day long, but that QSIP is open. It hasn't been canceled and discharged. The case is still active.
So Todd, back to the beginning here. You figured this out because of your dad was the court was broke, I guess,
Yeah.
back in the day in the 80s, right? They were broke. And then Ronald Reagan had passed a new law or a new commission of some kind to have the court get money from bonds. Is that how this all
Yeah.
started?
Yeah. That started because they were broke and they needed money. So just as the government always does, when they run out of money, they find a new way to tax us.
I see. So they started doing this and they started, making money on these securities from the taxes. And now basically the strategy is, oh, okay, if you're going to be doing that, will you please show me all the accounting, please? I want to get the records so I can find out what's going on.
Yep. And then
And they don't want to.
they avoid the Brady rule. So if you try to use the Brady rule against them for exculpatory evidence, they say, well, we don't have what you're asking for, so we can't comply with Brady. Brady doesn't apply. Oh, well, in U.S. tax court, we got this QSIP right here. We filed all these A's and C's and liens. Guess what? I liened my property. It will be coming out in U.S. tax court. You will not be able to avoid and not disclose the accounting. Somebody has it. And since you guys don't know who has it or claim you don't know, guess who has the terminals that can get it? Oh, that would be the IRS and the Securities and Exchange Commission. Because under Sarbanes-Oxley and the Securities and Exchange Act, if they don't have it either, everybody's committing fraud. Sarbanes-Oxley got put in place by Congress because the government was lying about the accounting.
So this is all starting to come out now. It looks like with this movie, and now people are learning about you, and you're really one of the leading, maybe the leading expert on this issue. It sounds like, and so you do a lot of consulting, and is that what people how it normally goes for you, or what?
Yeah, I mean, the main thing that I do is this what I was brought to the INC conference where I met Sarah and everybody else at the conference is to tell people that you need to have everything in complex irrevocable trusts to protect your assets because the government's doing everything in their power to tax you and take your property. I was very fortunate enough about 4 or 5 months ago, I was brought in by Merrill Lynch to a very high-end business meeting for high net worth clients, minimum 10 million. And they wanted me to kind of like audit the little couple-day conference that they did. And I told them at the end of the conference, a couple days later when we met privately, that I was actually very proud of their attorneys that were there and their CPAs that they brought in for their clients. Because the one thing they expressed to all of them is if you don't have an irrevocable trust, you will not be our clients. We cannot protect you. The government is here to take everything from you. That was the core takeaway of the conference to all of their high net worth clients, where they were basically moving their equity position in their corporations as the owners to the irrevocable trust, right? And then throwing everything in the irrevocable trust. Now, the attorneys can only do grantor irrevocable, so they can't split legal and equitable title because that violates their statutory codes. They can't do the complex, and that's what we talked about at the private meeting afterwards. And they're not comfortable in the complex irrevocable trust side because they don't understand the accounting rules. The CPAs generally got the concept of that it's a pass-through entity, but they weren't familiar with doing the accounting for it and didn't really want to go down that path of going back to the IRS for the complex training. So that's what we were talking about, the protection using complex irrevocable trust and then hitting everything through the accounting side.
Wow. Well, any last comments or questions from anybody before I wrap up here with Todd? We want to thank him for coming on. Anybody else have their hand up? Okay, Lisa. Lisa, yeah, go ahead, Lisa.
Go ahead. Sorry. I was just going to ask Todd, can I contact you for a private consult?
Let's wait till we get off the recording before we go to that, and we'll do that too.
Sure. Okay, great. Thanks.
Yeah, go ahead, Sue Frost.
Hi, Todd. I just wanted to ask on the complex irrevocable trust, are you speaking of a private or a public entity?
No, they're private only.
Private only.
Private only. So don't confuse that with, I've had a number of people have me audit their trusts. They're calling them complex, what do they call them? Complex, irrevocable, discretionary spendthrift trust. And I just have to shake my head. No, that's not what these are. Those are actually identified as the IRS by sham as a sham trust because they're not set up properly, and they are set up to do tax evasion. So these
Does
follow
this
the IRS rules for subchapter J to operate as a pass-through for accounting, splitting legal and equitable title properly. The IRS does approve these if they're written a very specific way, and they put them in file with your trust. So when you come at them and you're filing your taxes with them, or you're reporting your returns, they do recognize that and they do accept it operating this way.
What
So
and
we're
was the
not doing any
sham?
type of tax
rates
evasion.
under
We are doing standard accounting, which is identified as a pass-through, which is tax avoidance because you're doing your accounting, right?
you have an EIN number to so
Yes.
your bank account with the EIN and not this.
Yes, the IRS will issue an EIN number with the third digit, which is a 6 or a 7, which lets the IRS know that it's a complex trust and they expect you to do pass-through accounting. They expect you to 1099 every transaction, right? Remember what the IRS is. They are an administrative agency under Title V collecting information. They don't have it unless you assess it and give it to them. As the complex trust, they like us because you're telling them where all the money is going so they can catch tax evaders. What do you think every world government is trying to do right now with the electronic banking? They're trying to catch terrorists and tax evaders. Here you go. I'm a trust. What do you want? I'll give it to you. I'm happy to give it to you. Thank you very much for giving me tax credits in return, right?
They're
To
a
offset
collection,
our
they're
tax
basically
liabilities.
they're a collection organization, really,
Yeah,
right?
they're collecting information and you assess your own taxes. They have no authority to assess any data that you give them unless you commit fraud and give them the wrong numbers. Right? If you intentionally give them the wrong numbers, that's criminal. If you make a mistake, it's civil, right? So when you're on the trust side, you're saying, I'm just the trustee.
Basically, the
This is all the
IRS
data that
is
we have from the bank, and there's what we're going to report. Have
so
a
the
nice day.
IRS is our friend, is what you're
They
saying.
are our
And
friend.
yeah,
On the trust side, they are our friend. On the 1040 side and the corporate side, they hate you because they know you're concealing information from them. They hate you.
I see. But as a trust protector, they're your friend.
Well,
Yes.
I hope before it's over you tell us where we can go to learn more. I'm excited, inspired. Thank you.
Good.
Lisa,
That's
did you?
that's
Oh,
that's everybody's point. Lisa's point, my point, Sarah's point with the birthright is just understand that, yeah, we're kind of trapped in this matrix thing, but if you understand the difference between public and private, you give them what you're asking for with the accounting. They're very, very happy with you because you're actually helping them balance the books at the IRS. That is the core problem. The books at the IRS are a train wreck. So the people that are reporting fraud to the IRS with all these bonds and 1099As and all the people doing the stupid stuff like filing 1099As, trying to tap the minor account, they're pissing the IRS off because the books are all unbalanced and there's fraudulent entries everywhere. Literally, the department that fixes the 1099As is 3 years backed up. 3-year backup to fix anything. So we're very, very fortunate that we have people that work very closely with the IRS Criminal Investigation Division, both externally and internally, where we can kind of jump to the front of the line, right? We don't have to wait 3 years. And that's 3 years to our initial response where they say denied, right? Stupid. Now we're opening it.
did you have anything to add, Chris? If you wanted to.
Let's see. One of the few things that I'm concerned with what has not been spoken about, and that would happen to be the private to public mix here. I know that Todd had said that we need to stand on the private. Yes, I absolutely, totally agree. Everything I've built is based off the private, but shouldn't there be some kind of like a disclosure that yes, there may be this miner's account there, and what is my relationship to that miner's account to keep you in the private rather than to enter into the public?
Yeah, that's actually the estate conversion process that we do. It's very, very complicated. Lisa can, attest to you that it's not a fun process, but let me, hold on. I was going to put this in the comments too. So this is a general memorandum for what the estate conversion is and what needs to be done to stay private. And you have to understand that even when you do an estate conversion and everything's done properly, because the government presumes that 99.9% of the people are operating as a minor and a debtor in the system, they don't go and look before they take action and start filing tax records for you and creating bonds. And so this is a protection mechanism. It's not an attack vehicle where basically you can walk in and say, who are you? From where did you get your legal title authority to manage my estate? You're not the trustee. You're not the beneficiary. You are not a secured party. Who are you? Where is your contract? I don't see one anywhere. I've revoked and revested legal and equitable title. Powers of attorney have been revoked. Agency agreements have been revoked. Power of trustee has been revoked. Who are you? Where's the contract? Show it. Show your accounting. Right?
So,
This shuts
Todd,
them down very, very fast. If you got anybody that's even remotely competent in the space of the trust and understanding what you just said to them, they should run. And believe me, I've been surrounded by marshals, I've been surrounded by sheriffs, and I asked them these basic questions. I asked them the Sixth Amendment nature of their accusation, where their surety bond was at. I've literally been screaming at them to get back here. Give me your name and your badge number. They literally run.
so we don't answer any questions, but we ask questions.
Yes.
There's a very big difference.
Always to anybody that's in the criminal enforcement realm, what's the Sixth Amendment nature of your accusation right now? And where's your surety bond? You're operating under color of law. Who are you? I've yet to run into a single sheriff, even the sheriff here that's in charge, ask them the question. At the Masons Lodge, they've got the main guys in charge of the Masons here. What's the Sixth Amendment nature of any criminal action? I don't know. Well, you've been a sheriff and you've been in internal investigations. You've been in that realm. You have advanced degrees in criminal justice, and you said you never read the Sixth Amendment to the Constitution. He's like, I've never heard of this before. It's like, well, you better learn real fast because that's your job to protect both sides because you took an oath to protect that Constitution and you refuse to acknowledge the nature of your accusation because you're incompetent. You are a legally incompetent minor. This is why you don't know the answer to this question.
So, Todd, talking about what is the Sixth Amendment nature of it. So, if you have common law, you have equity, and you have culpable admiralty. Okay.
Yeah.
And
Yeah.
if you also look at the jurisdiction of it, so if there's no injured party in any of these statutes that they create, they actually are void because they violate CFRs and they violate the original Constitution. So when we look at the nature of it and we ask very specific questions of who was injured, what jurisdiction you're bringing this into, there is actually two questions. Let's go through both questions so they understand that. One is the Sixth Amendment nature, and then what is the jurisdiction?
Yes, the jurisdiction under Article 3, Section 2. What law form jurisdiction is this case being charged under? This is clearly an administrative court. Is it common law, equity, colorable vice? And you have to say colorable vice admiralty so that gets their attention really fast that you know the answer to the question. So something that my dad was very, very specific about is don't ask any questions in the courtroom you don't already know the answer to. So it's colorable vice admiralty because here's the 1099A, right? Remember, that's why I showed you the A and C form, right? You have accused it. And so if it's not a common law court because it's not an Article 3 court, it's administrative. That means there has to be a bond somewhere. I need to see your writ of attachment bond, your writ of attachment of body bond. I need to see the bid performance and payment bond, right? As soon as you start going after the bonds, they get really nervous really fast because you're just like, Your Honor, I'm very well versed that, bonds all have to be held in trust. So that's a trust. So I'm going to revoke and revest that right now. so we can do equitable subrogation. And if you think you're going to get around that, I'm going to see you in U.S. tax court for embezzlement. And I'm going to charge you as a named defendant because under the Seventh Amendment and Ex parte Young, you do not have sovereign immunity or judicial or absolute immunity for embezzlement and tax evasion. Nobody does. Right? Make sure you
When I
guys
asked
think
that to the
about having that
IRS,
argument with the, yeah. So here's the nice thing with your IRS issue, Sabrina, is did that judge have an SF-61 on file to not strike against the Constitution and the laws of the United States? And if you revoke and revest under Title 26 and he's an administrative judge in a Title 26 court and he doesn't do the accounting and you revoke and revest, you think he's going to show up in that courtroom?
nope.
Nope. Because you can literally look at the U.S. Marshal and you say, you are now my witness. The judge I revoked and revested. The judge just embezzled from me. Arrest him. You are an arresting authority.
So here's the link to the movie. Everybody, you
Thank
could
you.
check it out, and it's going to be at birthrightthemovie.com. It'll go into much more of a background and more of a story on there on all this stuff. And Todd is, going to be on the super highly advanced level. I mean, he's the one that's doing all the consulting and the strategy over these people. So it may be a little bit advanced for a lot of people that are seeing this for the first time, but there's actual enforcement. And I think one of the big takeaways I could learn from Todd today is like, there's a big difference between a notice and enforcement. And for years, it's always been notice, even the land patent stuff and all that. Yeah, notice, cool, but it's not an enforcement mechanism,
Yeah. Land patents are interesting because you do an administrative notice of affidavit of negative averment when they don't file for you. So that sets them up for all the penalties they're committing. Then you do a writ of mandamus in U.S. tax court.
There you go. That's your enforcement. Writ of
That's your
mandamus.
enforcement because they've created a system that is so difficult and cumbersome to navigate that nobody knows what to do. So you go to the U.S. District Court and you just say, we just need an easy remedy here, which is file. Here's my paperwork, file. I don't need to ask for anything else. You guys have the ability to scan this and drop it into your systems. That's all I'm asking for.
All right. Well, okay. Well, we got two more questions up before we end. Go ahead, Sabrina Max.
Just quick question. So when the question is asked about, the authority and so forth, and they come back and say it's frivolous, then I've dotted all my I's, crossed all my T's, and I could show up with the revoke and revest because they've just gaslighted me.
So now you know what we do with our team at the IRS Criminal Investigation Division. We ramp up all the documentation that you need to prove a willful criminal act has occurred of tax evasion and embezzlement. Now, once IRS CID opens that and we say, hey, one of your agents is involved, that's a 1203B1 violation, we can move to have him fired by the commissioner. They cannot say no to the accounting at the IRS, period. Not allowed.
I'm very inspired and excited, and I have a lot of this work done, so I can't wait to hear how to get more in touch with you, Todd. Thanks.
Yeah, it's just a process of paperwork. And remember, they're committing so much fraud, and this is sometimes so. The list that I showed everybody with those 30-something violations, sometimes I laugh and I tell them, I'm just like, dude, your list only needs to have like 5 things on there. They're already guilty. Why do you need 30? And they're just like, well, it could be about 200. And I'm just like, I know, you don't need 200. You need like 5.
Sue Frost.
Yeah. So, but that's a list for mortgage foreclosure fraud. That's the standard list that the IRS uses when they audit the courts for mortgage fraud.
Sorry. 2 questions. Number one, is there something in the IRS code right at the beginning that said nothing here is to be construed to be law? And so there are those who are out promoting that, you don't have, it's a voluntary thing. You sign the 1040 to pay. So you're not talking,
you sign a 1040. Yeah.
You're not talking about IRS code when you're talking about the felonies and the embezzlement and the fraud that's being committed.
So what do I look at the IRS and I say? Hey, you want to file that notice of lien? There's a CUSIP behind that. I'm coming after you. That's equitable subrogation. I'm going to set off and discharge that thing. Then I'm coming after you for filling out my tax forms. How do you think we beat the IRS? Go ahead and file that lien. Find out what happens to you.
But it's true. We don't really have to pay taxes. We don't have to participate, but someone's participating in embezzling from us on.
Are they filling out tax records for you when they do a lien and they fill out a 1099-A? Where did they get their authorization to file tax records for me? Where are these records that you filled out for me?
Okay, got it. And
So,
then
so people inside the IRS that will readily admit that the IRS is a joke, that the whole thing's a sham.
okay, and then on the allodial title, are you saying it's not necessary to go through that exercise? I mean, it's
Some counties will easily let you file a allodial title. Like for example, here in Hawaii, they actually have revised statutes for filing a land patent. They let you do it here easily, even on the statutory side. California is a different story. You have to take them writ of mandamus every single time. And believe me, I have all 310 Supreme Court and federal cases that California violates every single time. The Supreme Court won't even hear land patent violation cases out of California anymore because they've repeatedly told them they're breaking the law. They're operating under color of law by blocking your filings, right? So, but what California does is they're testing you, right? Oh, no, you're not allowed to file that. Fine. Affidavit of negative averment. You have 10 days to file. If you don't, here's your writ of mandamus. Here's all the violations you just committed. Here's our ledger of the penalties. You can either pay the penalties, which is going to be like $5+ million, or you can file. It's your choice.
or if you take control of your estate through a private trust, does that manage the land?
So you have to
Subject
understand land patents.
allodial.
You can't, for land patent, you cannot have a lien on your property from a bank. That's basic land patent act knowledge. So if there's a lien, you cannot split legal and equitable title and put it into a complex trust. Once you own it, you split legal and equitable title. Now you're under law instead of statutory, right? So you put it back under the protections of law, federal law, right? So now the state is taken out of the loop. But there's a number of different tricks.
They're not taken out. They're not taken out. You have to go through all this to get
Yes.
title.
Yes. Because the system got in the 50s got put into the statutory system. It got flipped. So now you have to unravel. Your point of doing the land patent is unravel all the colorable violations, right?
Good to do it.
Yes, and so I have talked to the Secretary of the Interior about this, and they do admit that places like California are absolutely batshit crazy, and they don't follow any laws. They just make shit up out of thin air, and it really irritates them that the state thinks that they supersede the Land Patent Act and the Homestead Act, right? That is written by Congress and is basically considered stare decisis as far as the Supreme Court is concerned. This
But the
is so
question,
well known, they don't even want to hear it in the courts because this counties are just hitting fraud and people are just bending over and accepting it.
okay, question though, if there was, I mean, there was talk in 2020 to 2022 that there was a bankruptcy, that the United States is already bankrupt and
Where is it?
conservatorship.
Where is it?
Pardon?
Where is it? Nobody's been able to provide it to me and I can't find it. Where is it? Has to be publicized. The last time I checked, they continue to register the corporation in Florida every single year. Go to
Florida,
record one.
Delaware.
Yeah, no, Florida. This is record 10009. They register
But
it
what
every
if
year.
they
It starts
just
in Florida.
what if they just opened a new corporation?
Where is it? Show it to me.
Yeah, I can't track it down. I
Yeah,
tried and
doesn't it? That's all a internet myth.
A lot of internet myths out there that people don't have any proof of. So
Yeah, that's why I tell people, show
hearing
me
about
the
that.
corporate registration because I still see them registering in all 50 states. It starts in
Should be
Florida.
pretty
It's
easy to
in all
find
50
if they were
states every year.
bankrupt. That would be easy to find
if
because
they
every
are
bankruptcy is
bankrupt and they have ownership of our
Yeah.
property, then we're part of.
Yeah, show me the congressional
But
records.
yeah, I
It
want to
has
see
start
I want to
there.
see the bankruptcy. I haven't
Show me
seen
the
it.
congressional records. It has to start there. They
Yeah.
have to issue the orders from Congress to issue the bankruptcy. They can't just do it in private.
Right.
They're not
Bankruptcies are
allowed to.
public.
They're public.
Yeah, 100%. A lot of myths out there
Yeah.
that that people had not used to, but anyway,
Yeah.
a lot of people. I heard that too many times. I don't
Yeah.
know where it came from, but
Yeah. So
long time ago.
one of the things that we issued to the judge about the trust for the U.S. tax court is I pulled the congressional records from 1967 that said that the entire government is held in the Sestakate Trust and that the people are the co-trustees and co-beneficiaries, right? We did Inri Bolins and a couple of other things that basically says everything's in a trust. And we're just like, oh, there's a trust. And it looks like, according to the federal government, we're the co-beneficiaries and co-trustees. So we're revoking and revesting this revocable trust. Why do you think that judge and the prosecutor didn't show up? Because I also told them to revoke and revest the birth certificate because we threw that in there with the QSIPs, and we revoked and revest the minor account with this unlimited credit. That's a trust. There's a custodian. There's a trust. Yeah, I want to revoke and revest unlimited credit. Please cut me a check for infinity. Why do you think they ran?
Yeah. So Todd, you said that Gene Keating, you saw him. He got a black card.
Yes, he probated his estate and revoked and revested it, and the Federal Reserve freaked out because he had the QSIPs for his friend number and his social security number, his birth certificate, everything. He had QSIPs for everything. He revoked and revested everything. They have to liquidate. They said, you can't liquidate an unlimited account, but will you take this black card? And he said, okay. He
Yeah, take this
contracted with them.
card.
Okay, $200,000 a month was the limit.
Just spend less than 200,000, Gene.
Well,
Hopefully
you could spend more than that, but you contracted to limit your spending to $200K a month.
yeah, try to live frugally, okay?
Yeah, exactly. Yeah, don't waste it. How much candy can you buy?
Well, thank you, Todd. Thank you, everybody, for joining in. And with Todd, everybody, check out that movie. And let's do it. Hopefully, we could do it again sometime. I think I'll get this out there on YouTube for everybody to watch and do a little short and get a promotion on it. So, yeah, thank you for joining us.
Yeah. So, and for everybody, just remember that's version 1 of the movie. Version 2, which has way more information, is coming out next year. And then there's going to be a bunch more things that trail onto that as well.
Nice. All right, yeah, check it out. It's going to be BirthRight BirthRightThemovie.com and on X. And all right, thank you, everybody. We'll see you at the top.